And good afternoon, everybody, and welcome to this BLP Lecture 17. And we're starting now our consideration of the insolvency part of the BLP course. And Units 17 and 18 are aimed at corporate insolvency, and ultimately Unit 19 is aimed at personal insolvency. Moving rapidly along. For the purposes of the BLP assessment, February of 2026, as you are well aware, five major headings. Partnership law and practice, and you can see the references there to the relevant BLP units. Companies and corporate transactions, again the references to the relevant BLP units. Taxation, and you can see there, I'm including references to foundation income tax, CGT and IHT, and then references to BLP units. Year-end accounts, units 8 and 16, and insolvency is the fifth of our major headings. Corporate insolvency, unit 17 and 18, personal insolvency, unit 19, but the emphasis in exam terms will always be on the corporate insolvency over the personal insolvency. There are a few little miscellaneous issues that I really want to mention to you, some interesting little points cropping up in Unit 1. Unit 6 actually is sale of goods, standard terms and conditions of supply. There are some aspects of employment law in Unit 14, and as I've just mentioned to you, there is some personal insolvency in Unit 19. But fundamentally it is five major headings with a few little miscellaneous issues that at least you should acknowledge. Do not forget, of course, that in the BLP assessment to comply with SRA requirements, there is also an unflagged 5-mark PCR question. But I would suggest that you are familiar with all of that already. So moving rapidly along now to today's lecture and our coverage. Insolvency, whether it is corporate or whether it is personal, what exactly do we mean by insolvency? Well, insolvency essentially is the idea that the business or an individual cannot pay its debts. Whether you can or cannot pay your debts essentially is an accountancy concept. It's a concept well known to accountants. However, that does not stop the law from giving you an entirely new significant piece of legislation called the Insolvency Act of 1986. Is the Insolvency Act of 1986 in your well-tabbed legislation manuals? And the answer, of course, is crystal clear. Yes, it is. That is something you have to look forward to. That significant piece of legislation has clearly been subject to amendments from time to time. For example, I make a reference there to the Corporate Insolvency and Governance Act of 2020, which was passed during COVID with a view to trying to alleviate issues for businesses confronting financial difficulties. The Insolvency Act of 1986 is backed up in a very significant set of rules prescribed by a statutory instrument, and that is the Insolvency Rules of 2016. You will be pleased to know that the Insolvency Rules of 2016 are not in your legislation manuals, and despite the fact we might make occasional reference to the Insolvency Rules, not going to be anything that you need to worry about unduly. But anyway, you see, when we look inside the Insolvency Act of 1986, we will find a reference to some formal insolvency procedures, actually reflected in the legislation in the Act itself. 6 formal insolvency procedures. And today we'll take something of an overview of those different formal insolvency procedures, albeit most of our emphasis today will be on liquidation, winding up, particularly liquidation winding up ordered by the court. In addition to the 6 formal insolvency procedures you find in the Insolvency Act of 1986, you'll also find reference to something called a members' voluntary liquidation. A members' voluntary liquidation, interestingly, is a liquidation in which the company can pay its debts. And to that extent, of course, it is a solvent liquidation, and therefore really falls outside the scope of a discussion of corporate insolvency. But it is actually reflected in the Insolvency Act of 1986. And before I move on, just to point out to you that when you are considering insolvency, and our particular emphasis is corporate insolvency, it isn't just about these formal insolvency procedures that you find in the legislation. Informal approaches to insolvency, for example, rescheduling debt, extending an overdraft facility, borrowing more money. These may be a way of dealing with financial difficulties, very effective ways of dealing with financial difficulties, but needless to say, you will not find them reflected in the Insolvency Act itself. So yes, this is a discussion about formal insolvency procedures, but I'll make a few more comments about informal approaches for a company dealing with financial difficulties. But most of our emphasis today is on compulsory winding up. That is a winding up a liquidation ordered by the court, as opposed to a creditor's voluntary liquidation, where the company is to be wound up because it cannot pay its debts. But it does not involve an order of the court. In fact, actually, it is initiated by the shareholders of the company passing a special resolution to the effect that it be wound up because it cannot pay its debts. So compulsory winding up, we should be aware of a creditor's voluntary liquidation, which does not involve an order of the court. Effect of compulsory winding up? Well, effect of winding up, whether it is compulsory or a creditor's voluntary liquidation, winding up is all about bringing the company to an end. Its assets will be collected in, its debts will be paid back to the extent that the assets actually allow, and the company ultimately will be dissolved and struck off the register of companies. Quite clearly, liquidation, winding up, is not about saving the company in financial difficulties. There is no element of corporate rescue when we are talking about liquidation. And the last entry on this slide, everybody, is a reference to a company called PrimeSound Limited. Our discussion of corporate insolvency will be done through the eyes of a company called PrimeSound Limited, not Ogan Shaking Ice Cream Limited. Okay, so in Unit 17 and 18, we'll be dealing with a company called PrimeSound Limited. I move on. Coverage today, well, that overview of those 6 formal insolvency procedures that you can see reflected in the Insolvency Act of 1986. I've already mentioned to you briefly this idea of a members' voluntary liquidation, which is a liquidation of the company, but it does involve the directors saying that the company can pay its debts, i.e. it is solvent. So to that extent, it's really outside the scope of an insolvency discussion. The purpose of compulsory winding up, well, as we've said, whether it's compulsory or voluntary liquidation, bringing the company to an end, realising the assets of the insolvent company for the benefit of the creditors. Who can use compulsory winding up? This essentially is likely to be used by an ordinary unsecured creditor of the company in question, an ordinary unsecured creditor of the company in question. How to use it essentially is procedure. So as this lecture progresses, I'll be making comments on a document that you may have heard of, known as a statutory demand. Effect of winding up order, well, for example, the director's powers will cease. This is the directors of the company against which the winding up order has been made. And furthermore, any floating charges created by the company against which a winding up order has been made will crystallise. So in other words, will convert from being floating into fixed. Role of liquidator to gather in the assets of the insolvent company which has gone into liquidation and to distribute those assets to the relevant parties in accordance with the correct order. And we can make some progress on that score very quickly, everybody, because let me see, who gets paid back first of all in the liquidation? Is it the creditors or is it the shareholders? And the answer, of course, is the creditors. But we can go further, can't we? Because then we can say to ourselves, who then gets paid back first of all? Secured creditors or unsecured creditors? And again, the answer will be fairly clear. Secured creditors will be paid back before ordinary unsecured creditors. So we've started to make some progress in that respect already. Risks to parties where a company goes into liquidation, whether it is compulsory or whether it is voluntary. Well, later on in the lecture, I'm going to introduce you to a variety of provisions within the Insolvency Act of 1986. Powers given to liquidators, interestingly also powers given to administrators of companies which have gone into administration, allowing the office holder to seek to maximise the value of the assets of the company in question for the benefit of the creditors. A series of statutory powers under which they can undo past transactions. So indicative there of what is coming up in the further comments. Vocabulary, as we become warmed up for the session. Well, insolvency and insolvent generally mean you cannot pay your debts as they fall due. As they fall due. Accountants, no doubt, will also appreciate a balance sheet approach to insolvency, on which you do a comparison of the value of the assets against the overall value of the liabilities, but in that respect, taking into account both the contingent and prospective liabilities of the company long term. So accountants can get very excited about whether a company is insolvent on a balance sheet test, but I think for our purposes we're best off by just confining ourselves to a discussion of, but can you pay your debts as they fall due? And it does not matter, of course, if a business has just turned a profit on its last P and L, but if it can't pay its debts as they fall due, it clearly has got problems. When we talk about winding up and liquidation, one and the same thing. When we talk about a creditor's voluntary liquidation, we may refer to that as a CVL. But a CVL is not to be confused with a CVA. A CVA, standing for Company Voluntary Arrangement, is a form of rescue mechanism. Whereas a creditor's voluntary liquidation is the equivalent to the liquidation ordered by the court. And of course, the function of liquidation is to bring the company in question to an end. You can see the reference on the slide, everybody, in red, to administration and administrative receivership. Briefly at this stage, when you are dealing with a company in financial difficulties, I would like to draw to your attention a very significant creditor of the company in financial difficulties. That is likely to be its bank. Its bank, because there must be every chance that the bank has got security, is a secured creditor. And that security may involve a floating charge over the general assets and undertaking of the borrowing company. And here's a point that will be repeated on multiple occasions, everybody. The way the bank enforces its security, the bank is thinking about protecting, its exposure to the company in question. If the bank's floating charge was created on or after the 15th of September 2003, the bank by law, if it's seeking to enforce its security, must appoint an administrator. If the bank's security with a floating charge was created before the 15th of September 2003, the bank retains the right, even though it is exceptionally unusual in this day and age, to appoint an office holder called an administrative receiver. Are administration and administrative receivership one and the same thing? Actually, no, they're not, because the primary objective of administration is corporate rescue. But that is not the primary objective of a formal insolvency procedure known as administrative receivership. So we can't confuse administration and administrative receivership. We shouldn't confuse CVLs and CVAs, but winding up and liquidation is fundamentally one and the same thing. Well, the last reference on the slide, everybody, is to a QIP. Have you ever stopped to wonder whether a solicitor can act as a liquidator of a company, or as an administrator of a company, or even as a trustee in bankruptcy of an individual? And the answer is, to act as a liquidator, or as an administrator, or as a trustee in bankruptcy, you must be a QIP, a qualified insolvency practitioner. And the truth of the matter is, everybody, is that a very significant number of QIPs will be drawn from the ranks of the accountancy profession, not from the ranks of the legal profession. But that does not stop a solicitor from specialising in insolvency law giving advice to QIPs, or giving advice, for example, to creditors of a company, or giving advice to the directors of a company in financial difficulties. But to actually act as a liquidator, or as an administrator, or as a trustee in bankruptcy, you must actually be a QIP and have passed the relevant insolvency exams. So very good, everybody. These four insolvency procedures which I have been talking about, reflected in the legislation. So very, very briefly before we forge on. So who can commence these procedures? I invite you to stop and think about a variety of characters when you're dealing with a company in financial difficulties. Ordinary unsecured creditors of the company in financial difficulties. The bank with the benefit of security. And also, what about the directors of the company in financial difficulties? So there you've got a series of relevant parties that might be interested in commencing insolvency procedures. How to commence? Well, fundamentally, that's nothing more than process. Well, let me see. We've already drawn a comparison between a compulsory liquidation, which involves an order of the court, as opposed to a creditor's voluntary liquidation, which does not involve an order of the court. Administration might involve an order of the court, but not necessarily. It could be initiated simply by filing relevant documentation at court. But that one fundamentally comes back to procedure. The basic purpose of these procedures, the primary objective of administration, is corporate rescue. Whereas the objective of liquidation winding up, is nothing more than to bring the company to an end, to realise the assets for the benefit of the creditors. So clearly very different. The basic effect of the procedures. The illustration I'll give you there, everybody, is that actually in order for a company in administration to try to achieve corporate rescue, that is much easier with a legal device thrown up around the company called a moratorium, a statutory moratorium where a company has gone into administration. So some general comments there about these insolvency procedures that you see reflected in the Insolvency Act. We're dealing with a company called Prime Sound Limited, so we will be looking at it through the perspective of ordinary unsecured creditors, the perspective of the bank, the perspective of the directors of the company. As always, as the solicitor, you must identify who is your client, and you must act in their best interests. And we'll be thinking about these formal insolvency procedures, and what may or may not take place in relation to this company called Prime Sound Limited. So, formal insolvency procedures. We made enough references to this, but there are those 6 formal insolvency procedures that you can see reflected in the Insolvency Act 1986. And on the left-hand side of the PowerPoint slide, everybody, number 1, compulsory winding up, compulsory liquidation, ordered by the court. By comparison with number 2, a creditor's voluntary liquidation, which is a liquidation but does not involve an order of the court. We can have a creditor's voluntary liquidation because the shareholders of the company have passed a special resolution to the effect that it be wound up, brackets by virtue of the fact that it can't pay its debts. You can see my reference to a member's voluntary liquidation in red, but as I made comment to you already, a member's voluntary liquidation is one which goes hand in hand with a statutory declaration from the company's directors that it can pay its debts. Well, if that is true, the company can pay its debts, then of course it's outside the scope of this discussion of insolvency. No further comments. Number 3 and number 4, just touching upon what I said to you before. Administrative receivership and administration. Let me see. When you think of administrative receivership and administration, I think the starting point is to say, what about the bank, which has extended credit to the company in financial difficulties? The bank is most likely in practice to have security. A floating charge over the borrowing company's assets and undertaking. Where that floating charge was created on or after the 15th of September 2003, where the bank seeks to enforce its security with a view to recovering the debt due to it, it will end up appointing an administrator. And the primary objective of administration is corporate rescue. But in unusual limited circumstances, where the bank security was created before the 15th of September 2003, the bank is at liberty to appoint an office holder called an administrative receiver. But you see very few of those in this day and age. A couple of other rescue mechanisms, everybody. A CVA, Company Voluntary Arrangement, reflected in the Insolvency Act, and this moratorium, reflected in Part A1 of the Insolvency Act, was a new device introduced during COVID. The good news for you, everybody, is that in assessment terms, what is this really all about? Where is our focus? Where is our emphasis? On compulsory liquidation, on creditors' voluntary liquidation, and while we should appreciate the distinction between administrative receivership as opposed to administration, our emphasis really would be on the possibility of the company ending up in administration. So we're taking something of an overview there, but our real focus will be number 1, number 2, and number 4. And remember, everybody, that this is Lecture 17. Well, this will continue into Lecture 18, which is a treat awaiting you in the first week of January of 2026. Like to see some statistics? Well, here you go then. There are the insolvency statistics for July to September of 2025, the third quarter of 2025. And it makes actually quite interesting reading. That in that quarter, there was a total of 931 compulsory liquidations ordered by the court. Look at the very significant number of creditors' voluntary liquidations, where the company ended up in liquidation, could not pay its debts, but did not involve an order of the court. So clearly we must be aware of CBLs. Administration's 392, and it is those first three where our focus, where our emphasis will be. CBA's 45, administrative receiverships. As I mentioned to you before, only where the bank's security, including a floating charge, was created before the 15th of September 2003. So in reality, very unusual in this day and age. Very rare. I've had that total up for you, everybody, 6,129, and I did so to draw a comparison with the statistics for the equivalent quarter back in 2024, where it was 6,398. So you may say that is a modest drop-off across 12 months, the third quarter 2024 to the third quarter 2025. There have been a very small number of this new moratorium procedure, which was introduced during COVID. Since the 26th of June 2020, which of course was right very close to the beginning of the COVID pandemic, through to the end of September 25, there have only been 64 of these new moratorium procedures now reflected in Part A1 of the Insolvency Act. That is of no great concern to us. We will make some comments on administrative receivership, but they're very, very rare in practice in this day and age. Most of our focus really is on compulsory liquidation, creditors' voluntary liquidation, and also administration. I mentioned to you 10 minutes or so ago, as you think about companies in financial difficulties, it is not simply about formal insolvency procedures. If a company is struggling to pay its debts, it needs cash. Let me see. One way of raising cash is to sell off assets. It begs the question as to who's going to buy the assets and how quickly you can actually raise the funds. That is a way of dealing with debts that you are struggling to pay. Will you find that reflected in the Insolvency Act? No, you will not. An informal approach to a company's financial difficulties. If we are not satisfied with our profits and are concerned about our liabilities, we may look to cut costs. For example, making our workforce at least part of it redundant. Refinancing. We're struggling to pay our debts. We go and talk to the bank, potentially about extending the overdraft facility. The bank may well say, well, we're going to extend the overdraft facility, we need additional security. That may also be a way of a company dealing with financial difficulties, but you clearly won't find it in the Insolvency Act of 1986, any more than, for example, the majority shareholder, managing director of the company, puts his or her hand in pocket and finds some money to throw at the problem. So, not just about formal insolvency procedures, also let's at least keep our eyes open about informal approaches to a company's financial difficulties. But that feels like a very thorough, comprehensive introduction to what is fundamentally now a lecture about liquidation, winding up. And whether it is compulsory or voluntary, creditors' voluntary liquidation, the basic purpose of liquidation and winding up is to bring that company to an end. The assets of that company will be realised, converted into cash, and distributed to the creditors in accordance with the order of priority. And as we can already see, who gets paid back first of all in liquidation, or creditors or shareholders, and the answer is crystal clear. Furthermore, of course, if this is an insolvent liquidation, we haven't got enough to pay our debts. This essentially means that there's going to be a shortfall on the part of the creditors, but clearly also the shareholders will not receive their share capital back from the company. And at the end of the liquidation winding up procedure, the company will eventually be dissolved, brought to an end, and struck off the register of companies. Absolutely fine. Who can use the compulsory winding up procedure? Well, let me see. The law's got a bit to say about this because it makes references to any creditor or creditors. It makes references to the company's directors, to the company itself. The reference there to contributory is essentially a reference to the company's shareholders. But for our purposes, this is most likely to be a procedure adopted by an ordinary unsecured creditor of the company in financial difficulties. An ordinary unsecured creditor of the company in financial difficulties. What is the procedure? What is the law? Please note, as I now look at this next slide, that the court has the authority to wind up the company. The court has got the authority to wind up the company. This is reflected in the Insolvency Act of 1986. And in particular, when you look at section 1221F, it states that the court may wind up the company because it is unable to pay its debts. Because it is unable to pay its debts. Now, interestingly, section 123 then goes on to tell you a bit more about what we mean by inability to pay debts, which, as we've said, is a ground on which the court can order the winding up of a company. Inability to pay debts. I'm just very quickly going to start off with the third bullet point there. Because, as an ordinary unsecured creditor, if you have got a letter from the managing director of the company that owes you money, and in open correspondence the managing director says, terribly sorry, we can't pay you, we haven't got any money, then I think you've got very clear evidence to go to court and to say, look at what we've got by way of evidence of inability to pay debts. Now, let me see, going back to the first bullet point, if we don't have something very clear, for example, a letter from the company which owes the money to the effect that they can't pay because they haven't got any money, how can we show to the court inability to pay debts? And this is where you need to take on board the first bullet point by serving a statutory demand on the company which owes the creditor money. Serving a statutory demand. Now, this is a document in the prescribed form, and it must be for a debt. exceeding £750. Must be for a debt exceeding £750. And this document in the prescribed form must be served at the company's registered office. And if then it has not been satisfied, or a satisfactory arrangement made for payment of the debt within the next 21 days, starting with the day after the date of service of the statutory demand, then you have your evidence of inability to pay debts. So okay, I started off by saying, point number 3, if we've got some clear evidence in open correspondence that the debt is not being paid because the company's got no money, but if we haven't got anything like that, the ordinary unsecured creditor can serve this document in the prescribed form, known as a statutory demand, for a debt exceeding £750 left at the registered office of the company in question, and if not satisfied, or an arrangement made for it in the following 21 days. Then you have your evidence of inability to pay debts, which will allow you to take the procedure on to the next step. Are all the ways of showing to a court that the company in question is unable to pay its debts? Well, in civil litigation terms, everybody, if you indeed have got a judgment in your favour and you seek to levy execution over the assets of the company against which the judgment has been made, and it is returned unsatisfied in whole or in part, that is also evidence of inability to pay debts. And at the bottom, everybody, this one will be very interesting to the accountants, where you could show to the court in question that taking a long-term view, the value of the company's assets is less than the amount of its liabilities, taking into account contingent and prospective liabilities. That is a balance sheet approach to insolvency. But I have to say that one is very much for the accountants, bullet point number 4. As a solicitor, you should be absolutely familiar with bullet points number 1, 2 and 3. And this idea in particular of a statutory demand. So moving on, everybody, where would we go after that? Applying for compulsory winding up, applying for an order for liquidation for winding up from the court. Do we have our grounds? Do we have evidence of inability to pay debts? So let me see, it could be because we serve a statutory demand and it's not being dealt with, but there could be other possibilities, as I've just alluded to. Now where do we go thereafter? We're talking about issuing a winding up petition at court. Issuing a winding up petition at court. That is going to cost us money. There is a court deposit. There are administrative fees, so this is going to cost us money. We should be aware of that. We're talking, if we decide to go ahead, about issuing the winding up petition at court. That in itself will require input from a solicitor, which will cost money. It is significant, the date on which the winding up petition is issued at court, because that reference there to section 129, the effect is as follows. If we issue a winding up petition at court on the 2nd of January 2026, and a winding up order is subsequently made by the court, hypothetically on the 2nd of April 2026, that for certain purposes, the commencement of the liquidation is backdated from the date of the winding up order to the date of the petition in respect of which the order was made. So we should always be very interested on the date on which the winding up petition was issued at court. See section 129. Anyway, that winding up petition will need to be served on the company in question. It will need to be advertised in the Gazette in accordance with the insolvency rules. That is something that we will return to in group session 18. And ultimately, having issued and served our petition and advertised it, we are looking at trotting off to court, are we not, on a hearing date, seeking a winding up order from the court. The court, needless to say, has got discretion. Now, looking at the bullet points at the bottom, everybody, and I've just added a new one in blue. It is important that you should note that, indeed, if the reason why the debt has not been paid is because there is a bona fide commercial dispute, we shouldn't really be going down this path at all. Bona fide commercial disputes over debts should be resolved via civil litigation. So before we decide to go down this path, as the ordinary unsecured creditor owed money by a particular company, we should be asking ourselves whether the debt in question is subject to a bona fide commercial dispute. Because if it does, and we proceed here with the winding up petition, it may well be that the court will throw it out, that the company in question, which owes the money, will see what is called a restraining order. We should stop and reflect upon that before we go any further. Perhaps we should do a company search against the company which owes us money. What that would show up would be whether the company which owes us money has created any security in favour of third parties. Because as you know, security created by companies must be registered within 21 days following the date of creation at Companies House, otherwise it's void. Assess whether it is worth it. What assets are we likely to be able to call on with a view to paying the debt owed to us? And the final bullet point as well, recovery of assets instead. If I have supplied goods to a company on credit terms, and I have not been paid what is owed to me, well, of course, if the goods were supplied under retention of title, meaning that the ownership does not pass to the buyer until the goods are being paid for, this now becomes a possibility on which I seek to recover the actual goods themselves that I have supplied. So, applying for compulsory winding up, the issuing of a winding up petition, the service, the advertising, waiting to see whether we get an order, but perhaps the ordinary unsecured creditor should just reflect a little bit on the bullet points mentioned there, the one in blue, but also the 3 in red, before deciding to go ahead with this. I move on. Let us assume that the winding up order is made by the court. Let us assume the winding up order is made by the court. What would then happen? A liquidator takes possession of the company and its assets. Effectively, you are looking at a cessation of the director's powers. You can see the reference on the slide, everybody, to the OR. The OR is a reference to a party known as the official receiver, who is an official of the insolvency service, which is part of the Department of Business, Enterprise and Industrial Strategy. And the official receiver effectively becomes an interim liquidator. The winding up order will be advertised in a local and in a national newspaper as is deemed appropriate. It will be advertised and notified also at Companies House. Your official receiver can call upon the directors of the company against which the order has been made, seeking a statement from them within the next 21 days as to its affairs. This is leading us to a liquidator's report. And ultimately, there is an important decision to be made by the creditors of the company against which the order has been made, whether they are going to continue with the official receiver as the liquidator, or whether they wish to appoint their own insolvency practitioner, QIP, to act as the company's liquidator. But whether we are continuing with the official receiver, or whether it's a new QIP that comes into place, that is essentially what we are dealing with. Note the statutory references on the right-hand side of the PowerPoint slide, everybody. So let me see if this winding up order is made. You can take reference of section 126 and section 130, because essentially, no court proceedings may now be continued against the company in respect to which the order has been made, without leave of the court. No great surprise there, really. And also take note of sections 127 and 128. This is aimed at events in the window between the initial date on which the winding up petition was presented to court and a later date of a winding up order. Because any disposition or property made in that window between the date of issue of the winding up petition and the later date of the winding up order is void unless subsequently ratified by the court. And likewise, any execution over the assets of the company against which the order has been made that are taking place in the window between the date of issue of the winding up petition and the later date of the order is also void. So some interesting sections there, and I particularly draw your attention to section 127. Any disposition of property made by a company against which a winding up order has been made in the window between the date of presentation of the winding up petition and the later date of the order, is void unless ratified by the court. The role of the liquidator. What's it all about, everybody? Well, let me see. Whether it's the official receiver, whether it's a qualified insolvency practitioner, it really comes down to the same thing here now, doesn't it? The objective of liquidation. The liquidator's got powers under Insolvency Act Schedule 4, and it's really about reclaiming the assets of the company in liquidation with a view to selling them, raising the funds, with a view to paying the creditors back in accordance with the order of priority. You can see the reference there to carry on the business, question mark. Let me see. Will I maximise value of a company that's going into liquidation by selling off the assets piecemeal, one by one, or by selling a business off as a going concern to a buyer, if there is indeed a buyer? If I want to maximise value, I will do much better if I can sell off a business as a going concern, as opposed to simply selling off assets piecemeal, one by one. But you see, the thing is, if we do think there is the possibility of selling off a business as a going concern, almost certainly it would be better off if the company was not in liquidation, but in administration, with the benefit of this moratorium, allowing the business to continue under the umbrella of the moratorium until we can find a buyer. But my liquidator, looking to maximise value, to pay the creditors back in accordance with the stipulated order of priority. Now, what do we know already? Who will get paid back first of all in liquidation? Creditors or shareholders? Easy. The creditors will be paid back first of all. One down, let's keep moving on. Who gets paid back then? First of all, secured creditors or unsecured creditors? Easy. The secured creditors will be paid back before the ordinary unsecured creditors. A little bit more complicated now. When we look at secured creditors, we must draw a distinction between assets of the company that's going into liquidation, which are subject to a fixed charge, as opposed to assets which are subject to a floating charge. If a creditor has the benefit of a fixed charge over an asset, subject to the cost of realisation of that asset, such a creditor gets the proceeds of sale. Full stop. What if I am a creditor with the benefit of not a fixed charge over assets of a company that's gone into liquidation, but my security is a floating charge over that company's assets? When I sell assets subject to a floating charge, can that creditor have the proceeds of sale first of all? No, it's not as simple as that. And now I draw your attention to the box on this slide, everybody, because you can see the reference there, number 4, to floating charges, whereas number 1 was fixed charges. And you can see the little red asterisk next to floating charges, because out of the proceeds of sale of assets subject to a floating charge, first of all, you must discharge the cost of the winding up itself. Secondly, you must then pay off the company's preferential creditors, which is certain amounts due from the company in liquidation to its workforce by way of unpaid salary. A certain amount of unpaid salary due from the company in liquidation to its workforce is regarded as preferential. And finally, everybody, certain debts due from the company to our friends at HMRC are also regarded as preferential. In particular, unpaid PAYE and VAT which has been collected but not handed over. Such debts due from the company in liquidation to HMRC are regarded as preferential in status and are paid in priority out of floating charge assets. And finally, everybody, but with more comment to come in due course, if you are dealing with assets subject to a floating charge, before the bank can get its hands on those proceeds of sale, number 1, the cost of the winding up, number 2, the preferential creditors, and number 3, this idea of ring fencing. A certain percentage of the proceeds of sale of assets subject to a floating charge must be set aside for the benefit of the ordinary unsecured creditors. So everybody, let me see. Creditors before shareholders, not a problem. Secured creditors before ordinary unsecured creditors, not a problem. Where did it become more complicated? We must draw a distinction between assets subject to a fixed charge as opposed to assets subject to a floating charge. Realistically, we are probably dealing with the bank having a floating charge over the borrowing company's assets and undertaking, and where the bank starts to have to rely on its floating charge to recovering the debt due to it. Unfortunately, it's going to have to take into account that before it can draw those proceeds of sale, number 1, cost of winding up procedure, number 2, preferential creditors, and number 3, even then, this concept called ring fencing. Okay, now once we've gone through all of that, the ordinary unsecured creditors coming in at number 5, and you can see that they are a long way down the order of priority. And let me see, if the company has got a total of £100,000 of ordinary unsecured debt, and there are only £40,000 worth of assets left to satisfy those claims, you can very quickly, very easily see that this company is insolvent. It cannot pay all its debts. And quite clearly, those ordinary unsecured creditors, there will be a shortfall. In very simple terms, everybody, where there is a total of £100,000 of ordinary unsecured debt owed to any number of ordinary unsecured creditors, but only £40,000 left to satisfy their claims, if you stop and think about it, everybody's going to get back 40p in the pound, 40% of what is due to them. Those ordinary unsecured creditors will stand shoulder to shoulder. So whether they owe a big amount of money or a small amount of money, they'll all be treated equally, receiving back 40% of what is due to them on the scenario I presented to you. All right, everybody, interest on debts. I'm very much surprised that's going to actually sort of come into play in this situation, and there are the shareholders right at the very bottom. And realistically now, this is where the shareholders will not receive their capital back. Effectively, they benefit from the principal limited liability. What have they lost? They have lost the value of their investment into the company. It will not be returned to them. So, okay, the role of the liquidator and the order of priority. Now, let me say when I deliver lecture 18 to you in January, I will return to this order of priority, and I'll have another go at it from the perspective of a company in administration, but we've already got a very good idea of what this is already about. Forging on, everybody, and in many respects now, sort of driving forward towards the conclusion of the lecture. I mentioned to you early doors in this lecture that actually there are risks to third parties where a company goes into liquidation, because the law has got a variety of statutory provisions giving powers to liquidators to have a go at past transactions who seek to undo them with a view to maximising value for the company's creditors. Liquidators' statutory powers. You will notice that there is a blue asterisk there. It is clear why there is a blue asterisk there, because the vast majority of what I'm about to discuss with you are powers given not only to a liquidator of the company, but the same powers are given to an administrator of the company, where the company has gone into administration. And what have we got on the slide here now? On the left-hand side, we've got a very interesting heading saying directors beware. Because where the company has gone into liquidation or administration, there are very clearly risks to the directors of such a company, because liquidators and administrators have got powers to seek to impose personal liability upon them, to contribute themselves to the assets of the company that's gone into liquidation or administration. So I'm going to talk to you briefly about wrongful trading and fraudulent trading, misfeasance, breach of director's statutory duty, and interestingly everybody, directors do beware because there is a separate piece of legislation called the Company Directors Disqualification Act of 1986, which is in your legislation manuals, empowering the court to disqualify an individual from acting as a company director, potentially up to a maximum of 15 years, albeit that would be quite exceptional that the disqualification period was 15 years. So directors beware. And on the other side of the slide, in addition to wrongful trading and fraudulent trading references, Section 238 of the Insolvency Act aimed at transactions at an undervalue, Section 239 aimed at preferences, and Section 245 invalid floating charges created by the company. What's the objective of the liquidator? But essentially it's the same for an administrator, to maximise value. To maximise value. They have statutory powers to help them along their way. So starting off now everybody, wrongful trading. Oh, I have to say, directors beware, because the law states as follows. But what you're seeing here, everybody, is a power given to both liquidators and to administrators, where a company has gone into administration. So let me read you as follows. Where a company goes into insolvent liquidation, or insolvent administration, if at any time before then, the directors knew, or ought to have known, there was no reasonable prospect of avoiding the insolvent outcome, then, and I'm just going to turn over everybody very, very briefly, then they should have taken every step which they should have taken to minimise the potential loss to the company's creditors. The company goes into insolvent liquidation, insolvent administration, if at any time before then, the directors knew, or ought to have known, there was no reasonable prospect of avoiding the insolvent outcome, then they should have taken every step which they ought to have taken to minimise the liability to the company's creditors. Let me go back. And if they fail to do so, in red there, everybody, the court can impose personal liability upon them to make such contribution to the assets of the insolvent company as the court sees fit. Oh. And where a director is found to be engaged in wrongful trading, it may well be that the court will disqualify them for up to 15 years at the same time as the wrongful trading finding. Finally, everybody, in determining what a director ought to know, in determining what a director ought to do, the court will take into account both an objective and a subjective test. A director must always meet the standards to be expected of an ordinary, competent person fulfilling the role in the company that the director in question was fulfilling. But not only that, if an individual director is possessed of special skills, for example, they come from a financial background, the court is likely to impose a higher standard of conduct on them. So in other words, that would be the subjective test, the ability and skill of a particular person if of a higher standard. So okay, everybody, that's very interesting, isn't it? This should be of great concern to directors where a company goes into liquidation or administration. Because I would suggest to you, they should start thinking about this potential risk of personal liability, not only when the company has gone into liquidation or administration, perhaps they should be thinking of it, if well advised, even before that point of time, because they should be highly worried about the risk of disqualification and the imposition of personal liability. Wrongful trading, everybody, is essentially aimed at incompetent directors. But meet its big brother now, everybody, because under Section 213, we have fraudulent trading. And exactly as per the heading of this one, fraudulent trading is aimed at fraudulent individuals, including the directors. Not just incompetent individuals, but fraudulent individuals. Because as it says, every person, but this will certainly be true of the directors, every person knowingly party to fraudulent trading, in other words, intent to defraud the creditors of the company, well, not only is that a criminal offence, surprise, surprise, but furthermore, again, the court can impose personal liability to make such contribution to the assets of the insolvent company as the court sees fit. Wrongful trading, both for liquidation and administration. Fraudulent trading, both for liquidation and administration. I move on. Delinquent directors. Where a company director is found to have breached their statutory duties owed to the company, a duty to act within their powers, a duty to act with reasonable care and skill to promote the success of the company, etc., then indeed an application can be made to court for an order to the effect that the director in question indemnify the company for breach of those duties. Now this is the one of these slides, everybody, where that is an application by a liquidator only. It's not a power given over to an administrator. Whereas the previous two, the wrongful trading and the fraudulent trading, were both for liquidators and administrators. This one is for a liquidator only. And now, everybody, 3 scenarios still to cover where liquidators and administrators can have a go at past transactions, by which I mean seek to undo them with a view to restoring value to the company in liquidation or administration, clearly then for the benefit of the company's creditors. The one we start off with here is transactions at an undervalue, Section 238 of the Insolvency Act, which clearly you will find in your well-tabbed legislation manuals. What are we dealing with here? A company has gone into liquidation or administration. If at some time before the commencement of the liquidation or administration, it entered into a transaction at an undervalue, now that would have been a gift or a transaction at an undervalue, by which we mean it disposed of an asset for a value which was significantly less than the true market value of what it disposed of. Gift or a transaction at an undervalue where it disposed of an asset for a value which is significantly less than the true market value. That period of time for which we can go back and seek to undo such an arrangement is 2 years prior to the onset of insolvency. And note the reference there, everybody, to Section 129. And recall what I said to you before, that where a winding up order has been made against a company, you have to go back and ask yourself, what was the date of presentation of the winding up petition? Because for certain purposes, the commencement of the liquidation is backdated to the date of issue of the winding up petition in court. So you're talking about 2 years prior to the onset of insolvency. And in the liquidation context, that's 2 years prior to the date of presentation of the winding up petition at court, on which the winding up order was subsequently made. So okay, this will allow the liquidator, the administrator, to go back and seek to recover assets disposed of by the company in breach of Section 238 for the benefit of its creditors. Now they're going to have to show that the company was insolvent at the time of any such arrangement, but note everybody, there is a presumption to the effect that the company was insolvent at the time of the gift or the transaction as an undervalue, where this was in favour of a connected person or an associate of a connected person. And I've highlighted that in green for you, everybody, because then you would say a connected person, to which I would say a director of the company is a connected person. An associate of a director, a family member. Parents, children, siblings. Parents, children, siblings. So we'd also be very interested as to in whose favour this transaction is an undervalue, in whose favour this was made. You'll see in section 238 subsection 5 that there are defences to any action under section 238. The party that has received the assets in question can always seek to defend itself on the basis that the transaction in question was entered into good faith, with a view to benefiting the company, and there were reasonable grounds at the time it was entered into for believing it would benefit the company. But you may say this is a significant power given to a liquidator or an administrator of the company to seek to undo past transactions now for the benefit of the creditors. After 238, we find 239. Preferences. Again, a power given to liquidators and to administrators. Let's set the scene for a preference. The company has got a series of ordinary unsecured creditors. 10 of them, hypothetically. Let me see. We do not have enough money to pay off all 10 ordinary unsecured creditors. I know. Let's pay off number 3 out of 10 ordinary unsecured creditors. We'll pay this one off. I wonder why they chose number 3 out of 10 ordinary unsecured creditors. Well, if it was the managing director's wife or husband, you may say, that sounds a little bit sort of dodgy to me. Preferences are aimed at that situation. A preference is the situation where you put an existing creditor in a better position than they otherwise would be on insolvent liquidation. Well, quite clearly, if you pay a creditor off, are they in a better position than they would be by being an unpaid creditor in liquidation? The answer is absolutely crystal clear, yes. For a transaction to be challenged as a preference, the liquidator or the administrator will have to make sure that it is clear there was the intention to prefer. There was an intention to prefer creditor number 3 out of a list of 10 creditors. But interestingly, everybody, where the alleged preference is in favour of a connected person or an associate, there is a presumption to that effect. An interesting point. Time periods for going back, 6 months or 2 years prior to the onset of insolvency. Think about the date of issue of the winding up petition of court. 6 months where the alleged preference is in favour of a non-connected person, but a whole 2 years where the alleged preference is in favour of a connected person. So you're going to be very interested in whose favour this alleged preference was made, because it's going to impact upon whether you can show intention to prefer, and it's also going to impact upon the time periods, how far back in time you can go. All right, everybody, preferences, section 239 in your legislation manuals. And finally, everybody, the last of them, section 245. Just briefly before I mention section 245 of the Insolvency Act, remember a fundamental point that you have already encountered from BLP Group Session 11, that where a company creates security over its assets, it must be registered at Companies House within 21 days following the date of creation of the security, failing which it is void. It must be registered on form MR01, and that must be accompanied by a certified copy of the debenture creating the security. So before I even discuss with you section 245, do not ignore the fact that actually security created by companies, any security created by a company which has not been properly registered under section 859 of the Companies Act, is void. Now then, on the right-hand side of the slide, what about Insolvency Act section 245? What is this one aimed at? It is aimed at the following, in particular, a classic scenario. A director of the company has lent it money in the past. A director of the company has lent it money in the past, but with no security having been given. The company subsequently gets into financial difficulties, and the director who has previously lent money is a bit concerned that he or she is not going to get it back in the event of liquidation. So what the company does is to give them a floating charge to upgrade them from being an ordinary unsecured creditor to being a secure creditor. But if this arrangement happens without any fresh consideration being given to the company in return for the floating charge, it runs a very real risk of being regarded as invalid. So if the director lent money to the company 2 years ago, an ordinary unsecured loan, now the company gets into financial difficulties, the company says, don't worry, we'll give you a floating charge, elevating you in status from ordinary unsecured to being the holder of a floating charge. Was any fresh consideration given at the time the floating charge was given to such a lender? And if the answer is no, then this is what this situation is aimed at. So let me see, how far back in time can you go to attack an arrangement of this sort of nature? If the floating charge for no fresh consideration was given in favour of a non-connected person, the time period is 12 months prior to the onset of insolvency. Remember the reference there to section 129 and the date of issue of the winding up petition. But if it's actually a floating charge for no fresh consideration given in favour of a connected person or an associate of a connected person, the time period now becomes 2 years. Before I leave this slide, everybody, I invite you just to stop and think about wrongful trading and fraudulent trading, dealing with directors in breach of statutory duties, and the series of powers, liquidators and administrators, under section 238, transactions of an undervalue, section 239, preferences, and section 245, invalid floating charges. And why are such powers there? Well, quite clearly, if liquidators and administrators can take advantage of them, we're talking about undoing past arrangements. We're talking about imposing personal liability on directors, all of which will then maximise value for the benefit of that company's creditors. So moving away from that, everybody, I draw your attention very, very briefly to section 423, transactions defrauding creditors. Where there has been a transaction as an undervalue at any stage prior to the commencement of liquidation or administration, at any stage where it was done with a requisite intention to defraud. I mentioned that one, and now, certainly with the end of the lecture in sight. We focused in today, everybody, on compulsory liquidation. That's a liquidation by order of the court. But you saw the statistics early on, and it's absolutely crystal clear that a majority of liquidations in this day and age do not involve an order of the court. They are simply as a result of the shareholders of the company passing a special resolution to the effect that it cannot pay its debts, and it needs to wind up, and it needs to wind up. So my focus here is on the left-hand side in red of CBLs, because as I've said to you already on the right-hand side of the slide, an MVL, a members' voluntary liquidation, is one which involves a statutory declaration by the directors saying that the company can pay its debts. Let's leave that one aside. The directors are the shareholders of a company in financial difficulties. The directors in particular should be concerned about their potential liability for wrongful trading and the risk of disqualification, so they may decide to pull the plug themselves. The creditors' voluntary liquidation. But they're going to need a special resolution passed by the members, the shareholders of the company. A special resolution in general meeting. Written resolution procedure can be used. Do not ignore the second bullet point there, everybody. As they set out to pass this special resolution to wind up the company, the CBL, have they got to tell somebody? They do. By law, they've got to notify the bank. They've got to notify the bank. The bank, realistically, having a floating charge over the borrowing company's assets and undertaking. And effectively now, the bank has first call. Dear bank, we are about to pass a special resolution for a creditor's voluntary liquidation. But we won't tell you first of all, you've got a floating charge. You may now decide whether you wish to push the company into administration as an alternative. And in this day and age, where the bank does enforce its security, it is highly likely that what is going to happen is that they are appointing an administrator. It would only be in really very unusual circumstances in this day and age that you never see the bank appointing an administrative receiver. So assuming that we do go ahead and the special resolution is passed because the bank does not want to step in and appoint an administrator, I pose the question, do the creditors then go on to choose the liquidator? The chances must actually be that indeed the nominee liquidator will be nominated by the board of directors of the company in question, although he or she must still be a qualified insolvency practitioner. So it is appropriate that at least we are aware of CVLs. And final comments, everybody, as the lecture comes to an end. Group session 17 in the first week of January 2026, and we're dealing with a company called Prime Sound Limited, as has been mentioned. You will see a letter from Richard Warlow, who seems to come across as the majority shareholder, managing director of this company. There is a letter from him. There is a document attached to the letter. I wonder what document it is. We'll look at your Unit 17 materials and you will see. As we start to think about this company called Prime Sound Limited, we'll be very interested via a company search as to whether actually it has created any security in favour of its bank. We want to identify exactly who are we acting for. Are we acting for an unsecured creditor? Are we acting for the bank? Are we acting for Richard Warlow in his own personal capacity? Are we acting for the company? And we'll start to think about which formal insolvency procedures would be relevant to this particular scenario. I think, everybody, that is enough for today's lecture, so I would really like to thank the total of 10 people who have very kindly stayed in room 307 with me through to the bitter end, making it a much more enjoyable experience for me. Thank you to those individuals who listen to me in person, and if you're listening at home, then good luck, enjoy yourselves, and I'll see you back in the first week of January. Thank you very much.
Thank you, Martin.